Okay, good morning, everyone. Buongiorno, if that's the right way to say it in Italian. I really am grateful to Professor Tognatti and his wonderful team to bringing us all together for this really fantastic conference. I think, you know, several of us have been in other conferences recently, and it's a step-by-step learning process all the time, you know, in millimeters, yeah? Becoming clearer about all sorts of issues, and it's really fantastic to be here in a new environment with some new people also, and it's very productive. Now, Professor Ferrari asked us 3 questions for this particular conference, and I just want to remind everyone of those because they should inform our discussions today, as we are embarking on a session that is focused more on theorizing than on maybe case studies or particular country perspectives. So the first question that he put was, why are personal law systems more frequent in Asia and Africa than they appear to be in Europe? And I think there may be historical reasons and reasons related to the nature of religions, which of course we are not clear about. Prakash isn't here yet, but it's obvious that we have lots to discuss, and it has to do with identity and all that. The second question was, to what extent are legal systems that incorporate personal laws an effective, that was your keyword, tool to govern religious diversity? And we are in a legal forum here, and so this is an appropriate legal question, but it may be the wrong question, because, you know, yes, legal systems can be tools and can be effective, but maybe there are other tools, there are non-legal elements and players and inputs that we need to look at, and I think we'll pick that up later. The third question is, can religious diversity be governed through other ways than personal law systems? And I have already my own answer to that, but I won't talk about it now. Professor Tognatti wanted me to talk about kites. I'm not doing that now. I'm going to talk about the moon. Because we all see the moon, but we see it in different ways, and we dream of different things when we see the moon. And I just leave it at that now, because I don't want to spend a lot of time. We have to be efficient. Quite a few of us have to leave at 1. And so I will give over to Lorenzo in a second to start. So we'll have one presentation, a discussion, then another presentation, and maybe even a discussion also before the coffee break at 11, and then we see how we go. And then I will wrap up, and then Marie-Claire Faublet will do the final wrap-up of the whole program, and I think that is really going to work very well. So over to Lorenzo. I discovered him in Trieste in a conference a couple of years it is now ago, no? And where we were preparing a book on Muslim, of the treatment of European courts, on Muslim dress codes and all these things. And then I realized, my God, this man is at King's, and recently you've become a full professor at King's, so that is fantastic news, yeah? And it's a great delight to welcome you here, Lorenzo. And so over to you and your PowerPoint, and I will move there because I want to see this myself.
Thanks. Thank you very much, Werner. Unfortunately, I cannot offer to fly as high as Werner with the kite, or I can't even offer to look at the moon. And in fact, my presentation is quite modest in scope and aim. It aims to clarify some tricky points and perhaps clear the grounds from misunderstandings. So bear with me. I'm a legal philosopher, so I try to systematize and somehow make a few modest points on the way. But before I start, let me just check. Shall we switch off the light, or can you see the presentation? So the topic I've been instructed to talk about is legal monism and religious pluralism within Europe, and more precisely from the viewpoint of the secular state in Europe. So that's what I will attempt to do. I need to make a few more preliminaries about this topic. The first one concerns the meaning of legal monism, which has been assumed so far, but it's not an easy idea to define. I will not attempt a full definition. I'm just saying that what I mean by legal monism is the idea that there is one legitimate authority. More precisely, there is one ultimate legitimate authority. So if there is a conflict between two individuals or between two communities, between two norms, there is one authority that is legitimately empowered to address the conflict. This does not mean that there may be other authorities. Of course, there are other authorities, but only one is legitimate in the sense that it has more reasons to settle the conflict. So this means also that legal monism is compatible with all kinds of pluralisms. So yesterday we talked a lot about pluralism, but I think that it is worth stopping for a second and saying that there are different forms of pluralism. So there is value pluralism, that is the idea that there are different values and each one of them is valuable in itself, and when they conflict, you can't really have a right answer between the two. But there is also cultural pluralism, which is essentially what multiculturalism refers to, the idea that there are a number of plural cultures, and yet it's very much a limited pluralism because, again, in the wake of what Michel said yesterday, it is the state that actually defines the boundaries of cultural differences. So, and they are very, very well-defined boundaries. So it's not full-blown pluralism. And then we have religious pluralism, but once again, in a secular state, the secular state is the ultimate and legitimate authority to define the bounds of what is acceptable as religious and what is not acceptable as religious. Take the example of Scientology. European states right now are struggling with the question of whether or not Scientology is a religion and can be treated as any other religion. So, it is the power, it is the secular state that has the legitimate authority to define pluralism. And so, there is no real incompatibility between the idea of one authority and many pluralisms. This is just as a preliminary to start the conversation. The main question for me today is the following: how should religious laws be treated by state secular law or state secular institutions? And some people have a straightforward answer, and they stop the conversation right there. They say there is no special treatment, and whatever is religious laws has to be treated informally, and it cannot be officially recognized. But of course, that is just a dream. The reality of life is that in one way or another, we have to deal with the existence of religious practices. Even if we have to deal with the religious practices, religious norms and principles, there is still an asymmetry between secular law and religious laws. So here, are the similarities between the two. Say, take as an example of religious law, Sharia law, for example. Both are system of norms, for sure, and both are also system of values. So they structure the community along those values by implementing a certain set of norms. And on top of that, both secular law and religious law attempt to define belonging to a certain community. And these are the similarities, and the similarities stop there. And that's where the asymmetry becomes more vivid or visible. When I talk about belonging, of course, there is a difference or a distinction to be drawn between belonging to a political society against the idea of belonging to a religious community. Now, perhaps Europe is unique, or it's an exception in the world in focusing so much on the importance and the primacy of the political society. This is something that we've inherited from the Westphalia Treaty, something that comes directly from the fact that we could not live with religious communities side by side without having an arbiter, an umpire that would not be religious. And that's why, you know, the Westphalia creates the political society, and the French Revolution entrenches the idea that the political society is takes priority over other community. In fact, the French Revolution attempts to wipe away the very idea of communities. There is only the state and the individual, and there is nothing in between. So to this extent, all modern societies, and because the Westphalia actually carves out the world map and draws the boundaries, to this extent, all modern societies post-Westphalia need non-religious laws to set up institutions, and in particular modern institutions. I would say that even theocracies like Iran or religious states like Israel obviously desperately need a certain amount of secular laws. But the fact of having secular laws does not overlap altogether with the fact of being a secular state. So you can be a religious state with a certain numbers of secular laws. So just to clarify, the two are not coexistent. The two are not perfectly overlapping. But the overarching point is that there is an important asymmetry between secular law and religious laws. Now, another phenomenon typical of European secular states is that secular law tends toward monopoly and hegemony. So it is a progressive tension towards monopoly and hegemony, and it's worth pausing for a second, trying to understand what monopoly means. And this is an important part of the topic, because I try to explain that monopoly happens at three different levels. So it happens at the level of production of norms, when the institutions produce new norms to regulate social behavior. But it also happens at the application of those very norms, when the administration or institutional bodies apply those norms to the day-to-day reality of the community. And it also applies at the level of interpretation or adjudication in courts, when litigation is brought to courts. So it's important to keep this separate, because it may well be that at one level there is a secular law, but at another level there is an opening for a form of accommodation. And I'm not particularly fast about where it comes in, but the point is that these three different stages are necessarily different, and one may be strict at one level and not strict at one other level in order to foster coexistence. But what extreme secular states say is that production, application, and interpretation can only be done by secular institutions and according to secular reason. I'm not endorsing this at all. I'm just saying I'm just reporting a default position that tends to be presented by strict, by those who defend the monopoly of secular law. On top of of monopoly, we also have what I call hegemony of secular law, and this comes in the fashion of this argument, the idea that the only reason that is understandable by everyone is secular reason. So secular reason inevitably always trump religious reason, and there is no real space for religious reason. This, of course, I don't really need to rehearse because it's a very long debate at the legal philosophical level. I mean, even Habermas and Rawls had to change their own positions in order to accommodate for the place of religious reason in their own theory. And this shows to what extent the hegemony cannot be fully justified. One-way hegemony will never be an accurate portrayal of the reality of institutional lives. So, you know, if you want another way of looking at it, maybe an easier one, is that secular states are not very keen to give voice to religious people at the level of production of norms. So it's only very recently that this issue has been brought up. But what I mean by this, no voice, is the idea that when a religious person comes up with a religious argument in order to produce a policy, then that policy or that voice is not in principle being heard. And on top of this, there is no real exit at the level of application. But both issues of voice and exit are now becoming to be under pressure. So the discussion about exemptions becomes more and more relevant, both at the level of day-to-day administration and at the level of court adjudication. So these two pressures make it necessary to reconsider the monopoly and hegemony of secular state laws as they are ideologically conceived. And I don't want to say that they have to be discarded altogether, but what I want to say is that monopoly and hegemony can be nuanced, and must be nuanced, in fact, because practice shows that they are not an accurate portrayal of the way in which European states, secular states, manage religious laws. To this extent, then I set out a typology in order to explain what are the options on the table. And again, this is a modest type of claim. The typology attempts to show what is there. I'm not necessarily taking a clear position. I'm just trying to clarify and produce a sort of common denominator. As I said, there are at least three different levels: norm production, application, and adjudication, which you can see on the vertical table, and this can be associated with 4 different attitudes of the state. So the state can say, as I said at the beginning, well, we don't give any special treatment. That's one position that you hear of the European secular state. Or you can say, you can try to carve out a space for reasonable accommodation, where it is unclear whether the reasonable accommodation is a matter of principle or a matter of practice. The next step on the spectrum, because it is a real spectrum, it's what we can call plural jurisdictions. So we have at the level of adjudication the acceptance of alternative dispute resolutions and so on and so forth. And the extreme end of the spectrum on the right, that is parallel legal system, tries to suggest that at the level of norm production, there could be two separate sources equally legitimate and living side by side, but not really intersecting one with another. You can discuss whether application and adjudication are part of these parallel legal systems. I am simply setting out that this is a legal system that exists side by side and does not intersect in the mind of those who defend it. So what I want to say, to do in the remainder of this paper is simply to show that the extreme polar opposite, parallel legal systems and no special treatment are definitely out there being claimed and being defended, but they seem to be, for different reasons, not viable options. So I think that from a conceptual and logical perspective, the real viable options lies between reasonable accommodation and plural jurisdiction. And I'm not saying that one is better than the other. I'm saying that that seems to be the core where the most important questions take place, and it cannot only be this way because the other two options are not viable, and I'm going to try to explain why this is the case. So the first option on the spectrum is the idea of no special treatment, when the secular states say no to any role of religion in the public sphere. And this coincides very often with the idea that the rule of law means one rule for all, and that's the end of the story. So you just have to accept the fact that one political community corresponds to one rule of law. And the next question is then, does that understanding of the rule of law allow for any special treatment of religious minorities? Obviously, for those who tend to identify themselves with no special treatment, the answer is no. But my point is that this position is often a non-viable position. First of all, this position is associated with a strict idea of formal equality, but this idea of formal equality, which comes with a certain idea of neutrality, does not cater or does not explain the existence of different burdens on different people. So an example that I think is relevant is the example of the French ban on conspicuous religious symbols. The idea of conspicuous religious symbols seems to be prima facie neutral, and it seems to pass the test of formal equality, but as we very well know, it discriminates between Christians and other religions whose symbols are not conspicuous. So there is formal equality here is compatible with an awful lot of indirect discrimination, and that's the first reason why no special treatment seems to be highly dubious. Now, the more important argument is that, no special treatment seems to put forward the idea that religious people have no voice whatsoever unless, and here comes in all the provisor, unless they translate and so on and so forth. But to me, this seems to be reductive, and certainly it doesn't make for it doesn't facilitate the creation of belonging in a political community, in the sense that the political community is telling some people that they can only belong if they accept the conditions of the majority. The second level, at the level of application, as I said, well, seems to suggest that administration of the law is formally equal, and so there shouldn't be any counter arguments. But as I tried to explain with the French legislation, application obviously involves a set of value choices that hide discrimination. And finally, at the level of adjudication, no special treatment means that there shouldn't be any exemption whatsoever. In particular, there is no exit for religious community, but this idea is justified in the sense that exemptions or exits should only be available to both religious and non-religious people. So this, again, functions along the line of formal equality, but as I tried to explain before, formal equality creates differential burdens for non-religious people. For religious people, non-religious people have the option to voice their complaints at the level of production anyhow. So they have a preferential way in changing the norms through parliamentary procedure, for example, something that is not readily available to religious people. And so it is somehow ironic that at the level of exits, the same conditions apply to both religious and non-religious people if at the level of production they are already discriminated. So all in all, it seems to me that in any cases, no special treatment is not capable of explaining what the practice of religious laws and the practice of conscientious exemptions doesn't seem to be capable of catering for a proper type of answers to the questions that we raise. So the second option on the spectrum is what I presented as accommodation, or some people call it reasonable accommodation. And in this case, the idea is that the rule of law is compatible with the idea that it doesn't have to mean one single rule for all. It simply means that there is a differential types of rules according to the different needs of the individual or the community. And this is not incompatible with legal monism as I defined it at the beginning. So it's still very much legitimate to treat different people differently. So accommodation somehow already takes place at the level of norm production, in the sense that, as we saw yesterday also with the cases Marco presented, the secular state has the legitimate authority to grant powers to religious organization, and this means, in other words, that religious organization or religious groups can have a limited degree of autonomy, meaning a limited degree of creating or giving certain rules to themselves. I'm not saying that it's an independent power of rule-making, but it's instead a dependent power of rule-making, but the secular state has the faculty of granting or creating this autonomy, and perhaps even it can take it away. At the level of application of norms, also there is already, and what I'm saying is that descriptively this is the case, and that's why no special treatment can be really justified because accommodation already takes place also at the level of application on a day-to-day basis. You may want to draw a distinction between principle and practice. So, for instance, the principle is that, say, in a secular state like France, abortion is permissible, it's legal, and yet it may well be that a religious doctor raises hands and say, well, I want to be exempted, I want to be accommodated, because I think that abortion is incompatible with my own beliefs. Now, the distinction of between principle and practice here is important. One routinely see the possibility of an individual to say, well, I don't want to do it. It doesn't mean that my colleague will not do it. The institution is still providing the service, but the institution is also accommodating certain people that do not wish to be part of certain activities. Now, I think that this is one of the biggest questions right now. Of course, the Ladel case, the registrar of gay marriages is another example. So, and it's a very intricate debate about whether or not there is a room for accommodation. I think that routinely, in practice, institutions could not live without granting a certain room of maneuver. You cannot just tell everyone you have to do it this way, it's the secular way, or there is no way. But of course, the fact that in practice this happens still doesn't settle the principal issue. Of course, many people raise the problem with Ladel. She may be capable of doing other things than registering gay marriages, but there might be a dignitarian harm in the fact that you allow public officials to take a stance towards gay marriage sends a positive or a negative message to the whole community. I think this is a very, very important debate, and I don't want to settle it right now. What I'm saying is that secular states are completely uncertain as to the right boundary to draw, and the action is taking place at this level. A lot of the action, and implicitly this rules out the no special treatment idea. Now, at the level of adjudication, it's also clear that, as we mentioned, conflict of laws, all sorts of accommodation is taking place in practice. And again, it may not be fully kosher, but the practice shows that if you take polygamy, for example, you may find a lot of cases of polygamous relations that took place outside of Europe and then are litigated within Europe. Of course, the principle, as we know it, is strict prohibition. However, again, practice shows that to a certain extent, the judges, courts, have to take into account those cases of polygamy, especially, for example, when the man is trying to play the system by claiming that he cannot be seen as owing an obligation to one of the wives because the European legal system only allows one marriage. So to this extent, French courts have allowed the recognition of those polygamous relations in practice and have granted some legal consequences. So obviously, we can say that to a certain extent, accommodation is coming into adjudication through the back door. There is no real explicit open air discussion on what to do, but there is a lot of practice of accommodation taking place in courts. And so both at the level of adjudication and application, just to take a broad look for a second, you can see that special treatment is really not an option. It cannot be used as an argument that explains the practice as we know it. Most of the action takes place at this level, and at the next level, meaning the idea of a plural jurisdiction. So I said before, there is a question between back door or front door. The UK, for example, with the Arbitration Act 1995, gives an example of front door accommodation, in the sense that, well, it opens up the door to the possibility of litigation or of establishment of a Jewish court or a Sharia court, and so on and so forth. Again, even if this is opening a door, the discussion is not always frank and open. We know very well what happened with the Archbishop of Canterbury, simply stating something that existed in positive law, namely the Arbitration Act 1995, opening the door to the acceptance of Sharia law adjudication. Now, at this level, as I said in the typology, norm production and norm application are still very much secular, and it is at the level of adjudication that all the action takes place. So, as we very well know, at this level there is a certain room for religious arbitrators, which again, and it's very important, it's part of the main points, is not incompatible with the idea of legal monism. So the fact of having one legitimate authority is not incompatible with the idea of having a plural jurisdiction or plural courts. So I'm also resisting the idea that legal pluralism would be a more liberal or better option, or more enlightened, or more desirable option. I think that you can square most of this within the idea of a secular state having a monistic voice. And it's the idea that we are still located in one legal system. But it is, and I come to the conclusion with my last option. So it is this last option that, again, I defined as extreme and therefore non-viable. It's the idea of acceptance of parallel legal system, systems that would exist side by side and would somehow be equally valid and claiming equally legitimate voice. So the question is, can we have in Europe state law? Well, can they be separate but equal? And my answer to that is that they cannot be separate and equal. And if anything, there are several problems with the idea of parallel legal systems. So there is a very, very basic problem with the idea of parallelism if you take it seriously as a metaphor. Obviously, it is only a metaphor, but parallelism means that there are two body of norms, or there are two objects that live side by side without ever intersecting. Now, this is logically flawed in the sense that the whole point is that at one moment or another, there is an intersection. There is, the whole point of our discussion is that at one moment, at one point, there is a conflict. And so the real issue, the real question here is whether or not conflicts between personal laws and secular laws are solvable from within the secular legal system, whether the secular legal system has the resources to decide cases that require an awful lot of knowledge and also perhaps stepping into areas that are very treacherous. So this is the picture I wanted to paint, and as a very quick conclusion, you can see I want to discard the two extreme opposites, no special treatment and parallel legal systems, to focus on these more interesting options by saying that, well, to a certain extent, accommodation and plural jurisdictions are something that the secular state has to tackle open-endedly. It has to engage in an open deliberation about how much accommodation do we really want, on the one hand, at the legislative level, and at the level of application, it has to engage on a discussion on how much are we prepared to accommodate in practice certain claims and requests. And I stop it there because it's the end.
Grazie. That was really fantastic. Very carefully argued, I think. And so I think we'll open up for a discussion now. But before we do this, your presentation and your perspective focuses on the state as the producer of legal norms. And I was reading, because while most of you were sleeping, I was reading my last doctoral student's thesis. He has his exam on Tuesday. And he has produced a thesis about norm production by members of the Muslim community. And for the first time, you will be very interested in this. We have now real evidence. 37% of all Muslim marriages in Britain, according to that research, remain unregistered. People know what the law is, but they make their own laws. Yeah? So how should the state in that situation react? Do we then criminalize non-compliance with the authority of the law, or what's the way forward? That would be other questions. But thank you so much for this very careful presentation of what's going on. Yes?
I want to push you a bit on what you call reasonable accommodation, and why isn't it possible to conceive of the freedom of association that exists in any Western democracy as taking care of what you call reasonable accommodation? People can congregate, they are able to create an organization. You would have bylaws for that organizations that would instruct members that would opt in. So what you would be calling, if it's not the freedom of association, and it could be something else, then you would be going to a kind of a parallel system, because what is something else? It's a place where the organization can instruct you to do something when you're not able to opt in. So what is this reasonable accommodation that is different from the freedom of association that exists? And I'm not just inventing this, it's an argument made by Brian Berry, which he says in his book on equality and justice. All of what you need to do is just recognize the freedom of association, and people can have this congregation, can have this community through what we offer by regular principles of a democracy. And I want to push you a bit on the last category, on parallel jurisdictions. Does it really exist anywhere in the world? I mean, in any place where it exists, it's instructed by the state. The state would say that you are able to have two systems of laws and people are governed. There is no such thing without the norm of the state that would be instructing. So can you think of an example? I certainly cannot think of. I mean, even in theocratic states, it is the state that is instructing. So we go back to the state. So there is no genuine parallel, I think, from my perspective. So these are the two main questions.
directly on this? No. Okay. Then Arif, we take you first. Shall we take several questions? You okay with that? Yeah? Okay.
Okay, thank you. Thanks, Lorenzo, very much for the typology, which I found very interesting. My question is about the analogy. Well, my question is to add a bit of complexity, or to see if this complexity challenges your model or would revise it at all. On the analogy between state law and religious law. So you gave the example of the Sharia law, but I think this could also apply maybe to Jewish law, to rabbinical law. Is there a problem, does it become a problem, if these religious laws do not have the coherence of state law? That is to say, if these religious laws are not internally monistic. So some of them might have very plural expressions in and of themselves, and does that become in any sense a problem for either accommodation or for plural jurisdictions?
Can we give the mic to Professor Ferrari, please?
On the same point of a difference analogy between religious law and, let's say, secular law, I think that one of the explanation of the tensions between the two, in my opinion, is that religious laws are mainly personal, while secular law are mainly territorial, state law I have in mind. And so states have some problems in controlling religious communities because they bring their laws with themselves. For example, the Muslim living in the UK listen to the Mufti in, or whatever authority in Damascus, and follows the fatwa that is enacted in, I don't know, everywhere, but not in the UK. This makes the UK authorities a little nervous because they are not able to control. And the Muslim living in the UK, he feels he is compelled to obey that fatwa because it is part of the religious law he brings with himself when he comes from Morocco, Tunisia, whatever, to the UK. This, in my opinion, explains the tensions between the two laws.
Now, I have some minor points regarding your assumptions and your wording, and they're related to what Arif was saying. You mentioned about similarities, that both are systems of laws. Well, students of Islamic law would tell you that actually Sharia, as you called it, by no stretch of imagination can be considered a law as we consider it as, let's say, our law. I mean, it was, if by Sharia you mean classical Islamic law, it was more of a mode of argumentation, ethos, reasoning, and it had an inherent difference that where all differences were legitimate, that did not make it actually a system of law. So I know that, I guess for the sake of simplicity, you had to say it, but it's an important assumption that actually is not exactly true. Of course, if by Sharia you meant Sharia-based state laws, then of course there are similarities, because Sharia-based state laws are a product of a codification process under the influence of Europe. So it's a truism that the two are similar, if you see what I mean. And then you said, and I guess that's the theory, that secular laws tends towards a monopoly in terms of production of laws. That's the theory, but we are in a situation in which established churches and states have a problem with the sub-state regimes in terms of personal status, but apparently not many problems at all about the imposition from above and from outside the territory of rules, which have very important consequences also on societies, on cultures, and even on the concept of religion and on these models that you described. And finally, you mentioned twice or three times the term religious communities, religious people. And again, I'm sure you did it out of, to simplify. But I mean, of course, people have within themselves different identities, and we want to be careful not to box them into just one identity. They might want to have the right to exit in a particular moment, in a particular circumstance, like rational beings, from their identity. So I think it's a bit dangerous to use these terms. Thank you.
Take two more questions, Lorenzo. You're busy writing notes?
Yeah. Yes.
Yeah? Okay. Professor Toniati, and then Marco, and then we close. Yeah?
Thank you very much, Lorenzo. You gave a presentation which was beyond my best expectations from your participation here to this conference. So I really appreciated it. But I would like to ask your opinion on one point in particular. Let me just remind that I'm a professor of comparative constitutional law. And I would like to say something which emphasizes a sort of totalitarian potential of constitutionalism. And I'm referring in particular to hegemony more than a monopoly, in the sense that, in particular in countries, as in most of continental countries in Europe, we have entrenched constitutions, we have judicial review of legislation, and this is because we have hierarchy, and of course hierarchy of rules and hierarchy of values have very much to do with your monopoly approach. Now, higher values and higher rules are components of the identity of the polity. And I think this is a very strong limit on the possibility of accommodation. So I would like to, I wonder if you could elaborate more on that. And that's why I'm talking, or I'm referring to the potential for totalitarianism. Because, for instance, when it comes to principles of equality and the like, how much can the polity accommodate different values, in particular when those values are radically different from the ones that make up the identity of that polity? Thank you.
Professor Ventura, please, over there.
Thank you, Lorenzo. I would like to ask the legal philosopher about where you see effectiveness in your model, because this is not application, right? Where you talk about application, adjudication, interpretation, it's a different thing. But when Werner mentions people live by what they perceive as the norms, religion-based or culture-based, as a matter of fact, and they can even resist to some extent formal legal pressures, either from the secular state, sometimes even from established religious communities. This is very interesting to me in the sense that a lot of anxiety around is based on the fact that religious communities, including Scientologists maybe, okay, when they take vitamins or whatever, that's, as a matter of fact, their practice, and they're able to live by the practice, whatever the formal legal rules can be, and sometimes including religious norms, because there's also a lot of dissenting actions in the real way people live, from not only, state authorities, but also from religious authorities. There's a lot of dynamics in terms of how do you locate these elements in your model? Thank you.
Wow. Well, thank you very much. I mean, these are wonderful questions. Each one of them perhaps worth a whole new paper, I should say. Well, maybe I'll start with the final questions that goes back to the beginning. That is, where do I locate the practices? And this is very important. It's a very important question, so for me too. But I have to be completely honest in the sense that I'm not coming with an ideological perspective. I'm not saying that state law should morally be the only law. I'm saying I'm trying to step back and trying to work out what are legitimate norms in the eyes of the secular state. But I can immediately grant that the secular state may not thrive and survive forever, in the sense that in order to survive and thrive, it has to exercise legitimate authority, and this is one of the kernel of my position. And in order to exercise a legitimate authority, it has to be capable of explaining also to those people who practice religious norms on the ground, secretly, so to say, that they are better off by following state law rather than by following their own norms. I don't know whether the secular state is capable or will be capable in future to say so. So for the moment, I locate these practices, which I don't deny, in what I call the black markets of religious laws, in the sense that they exist, but they are not engaging with the official public sphere. So they are not. They exist as secret practices that the state needs to tackle somehow, but is incapable of tackling, because it is incapable to convince people that it's better to be living within the same community. Now, maybe it's an unsatisfactory answer, but that's all I have for the moment. I'll try to come back to these points. And this next question was Michel's question on freedom of association, saying, well, why wouldn't you explain reason of accommodation in terms of freedom of association, and that's it, you know, the state should be able to grant the opt-in and opt-out, and that's the end of the story. The problem is that, well, I would be perfectly happy to do so if all the issues were community issues. But in fact, accommodation also deals with the individual request of accommodation or exemption. And in fact, the example I mentioned, the doctor, the religious doctor, or the religious registrar are individual cases. So Mrs. Ladell or the religious doctors cannot appeal to freedom of association. Well, I mean, then you're already adding something to the picture. I mean, if you want to call accommodation with the label freedom of conscience, I have no problem whatsoever with that, in the sense that there is a huge overlap. I'm not attached to the label. I'm simply saying that through the freedom of conscience or accommodation, the state has to tackle issues that it kind of refrains from tackling. So I'm suggesting that this is something that has to openly resolve. The second question you raised was about parallel jurisdiction, and well, you said, well, are there any parallel jurisdictions in the world? And again, I have to say that my typology is a theoretical typology. So I presented it as it is, well, defended by some, but I agree with you. I cannot see in the real world an example of parallel jurisdictions. I don't think that it exists, you know, like, but some people claim, or Refah Partisi typically claimed in its own manifesto that it would want to have a parallel legal system in Turkey. I simply say that it's just impossible, so is the no special treatment is impossible when it comes to practice. The next question is was coming from Arif, and so it is about complexity, and you were asking whether it would create a problem if those religions are not internally coherent and if they are pluralistic. But maybe I can come back with a question. I mean, what kind of problems are you thinking about? So do you have an example of a problem?
Okay, well, thank you. Maybe this is an example. So in the Ontario debate about arbitration that happened in 2004 or something like, you had a number of Muslim groups that spoke about it, but they had a range of different opinions. And so actually there was no opinion that came out of all these different Muslim communities that could say this is sort of, as it were, a Muslim voice. So in terms of, say, a reasonable accommodation, what is the reasonable accommodation that should be applied? Does the fact that accommodation might have to be now, many more instances of reasonable accommodation, does that cause a problem or not?
From my perspective, well, again, it's not as if I am a great advocate of a reasonable accommodation. If anything, I see problems with it too, in the sense that I hesitate whether it's a good option. What I'm saying descriptively is that we cannot live in a world where there is no accommodation whatsoever. Some cases are egregious cases of violation. Maybe Ladell is an egregious case of violation, and you cannot allow a public officer to discriminate, even if it's not, even if it doesn't have consequences. I personally don't think that it should be allowed, but I think that in our life we have to have a room for accommodation. And what my preferred option is a prudential option. That is, whenever you can put forward the reasons of prudence, that is practical, instrumental reasons that justify the preservation of the status quo that does not lead to harm to anyone, then you should tentatively allow for accommodation. And this is always open to counter-arguments and principles that can overweigh or can prove. So I don't have special problems with any type of accommodation. One should come up with more details about what this accommodation is all about. That's why I asked for a clarification or for an example. Now, the next question is from Professor Ferrari. I think it's a very, very important question for me, and it brings me back to the initial point. That is, I agree that religious laws are mainly personal, and in today's globalized world, it becomes a real challenge for the state. And I don't want to deny that at all. In fact, as I said at the beginning, I just want the secular state to be aware of these challenges, and maybe it will, deliver some goods. It will be capable of answering these challenges, but it may not be up to this task. It's a real issue, and the survival of the secular state depends on its ability to talk to the minorities, say the ability of the French secular state to talk to Muslim minorities and convince them that they are better off abiding by the laws of the community. But this is a matter of legitimacy. It's a matter of being capable and coming up with good arguments of why they are better off being French citizen beside being Muslim citizen. And, as the things stand, I'm not sure that France is capable right now to perform this task, unfortunately. But the tensions that we see are, I agree totally, come from that inability to sell the laws of the state to people who bring something that they value more.
Your personal identity. I mean, national law can also apply on a personal level. It's not only applicable on a territorial level. It's a matter of degree, how much.
Yeah.
But even national law, I mean, I'm in Italy, I can't vote for the parliament. Why? It's not because I'm on the territory of Israel, it's because I'm not an Italian citizen. So national laws can also apply.
Exceptional cases where you move from your country and go to another country, that's not the general situation.
Well, but Muslims also live in the UK, and there is under Islam what's called the fiqh al-Islam, fiqh al-aqliyat al-Islam. It's like a doctrine of Islamic Sharia. For me, as if I was a Muslim living in the UK, how to adapt to secular laws of a country which is a non-Muslim. This is something that is now developed in Europe because of minorities living in a foreign land that need to abide by laws that can be in contradiction with their personal law, and it is something that is developed by Sharia in order to accommodate my territorial presence. So it plays in a lot of ways.
I think we agree. I think we agree on that, to be honest, and I think we also agree on the fact that that is the spot, the tension, coming up. So just to briefly finish, like I don't want to take too much time. I very much welcome the suggestion that here there is a little bit of simplification in the sense that I'm stepping aside and working with abstract concepts, so they do not allow for an awful lot of details. And I hope that the intention doesn't come across wrongly, in the sense that I certainly don't want to box or to entrap, as Michel would say, religious communities into these labels. I'm very aware of the fact that Europe is about plural identities, and the legitimacy of secular state laws is probably predicated on the ability of European secular states to allow the flourishing of plural identities. To send the message that nobody has one singular identity, but everyone has plural identities that they can let flourish in different ways, and that is perhaps a source of success, possibility of success for the European secular state to try and recreate from the bottom up a space in which everyone can be a Muslim, a French, and a European, and a Lyon supporter, and so on and so forth. And that's certainly true. If I simplify too much, and that is a burden to the possibility of this vision, then I will have to somehow correct what I'm saying and be more articulate in these systems. It is true that, for purpose of explanation, I do take Sharia law as Sharia law that is that works for a state and not the classical Sharia law. And
But the Sharia, let's say, that is applied by Sharia councils, at least I think about what I know in Italy, has not that much to do with the Sharia-based state law that is adjudicated in Muslim countries. And what Sharia, let's call it this, you decide to accommodate as a state, bears lots of political implications that we haven't touched upon. For example, which country and which vision are you accommodating? Because we all know that, at least in Italy, there are mosques and cultural centers that are funded from abroad, and they specifically push for a specific interpretation. So, I mean, this is an important issue that we should keep in mind.
But
what Sharia means also all these things.
Okay, but what you're raising is basically that the state is not the only person or entity in charge of the management of this field. So it's at the same time community organizations, religious organizations, individuals. My student writes that young Muslims in Britain become self-empowered muftis. They claim the right to define things for themselves, only to face criticism, of course, from their own peers and family. You know, what you're doing is completely haram. Yeah? You have no right to do this, but they do it nevertheless. So the state is up against all these challenges, and you are simply presenting here the state-centric perspective, and so...
Yeah, and so I totally welcome, your points of specification, and I just want to say that those are challenges for the state, to debate with them, and it's fine. So the next and final question was from Professor Toniati. Thank you very much for the question too. I welcome it as well because it's part of my broader project. If I understand your question correctly, is about constitutional identity and the extent to which the identity of the polity can be defined and whether or not it is capable of negotiating or navigating between norms that can live compatibly with that identity or not. And, part of my research, and here I also would like to thank the University of Trento because my book was finalized here a few years back. My project is also about positive secularism, in the sense that I would like to develop a position in which secularism does not simply define the constitutional identity negatively. That is, the secular state is anything that denies religion, full stop. I think positive secularism should be something much more than the denial of the social-political role of religion. Positive secularism should be the embracing of positive values that are capable of being shared by all members of the community, irrespectively of their own identities. So that would be a meta constitutional identity that I'm still working on, and I don't know.
I'm just afraid of the constitutional religion and the constitutional court being just a class of new priesthood. That's my concern. So.
And I think that's it is a reasonable concern. I think that's if we were simply to work with a black and white idea of secularism, something that is a negative one, then I would think that that secularism would amount to a religion that is exclusive and not capable of creating a legitimate authority.
Can I ask whether, I'm really intrigued by this positive secularism. Are you thereby saying that this positive secularism is actually a form of engaging with religions rather than trying to draw a wall or make a wall between law and religion? Because that's, I think, what you're saying, no?
Yes.
Yeah? Okay, that's helpful, definitely. No? Okay. I get several signs here that we should stop the discussion. I know that, but we'll have tea in a moment. Yeah, I've made sure that we can go for chai straight away. But let's just finish with your last response, I think. Or was this already?
No, Professor Toniati was
that was the last one.
Yes.
And yeah, because Marco has been. Okay, then we can go for tea now. Can I suggest that we come back at 11? Marco, you've been answered, no? Yeah. Okay. Yeah. So can I suggest that we come back at 11?